Bismillahirrahmanirrahim. Today I will be discussing the principle of istihsan, its meaning, its definition, and its parallel with doctrine of equity in Western jurisprudence. Some of the arguments that have arisen against istihsan and its relevance to contemporary law. Literally, istihsan, which comes from the Arabic root word hasuna, means to consider something good or preferable and beautiful. And it is translated in English as juristic preference. That is to say that the jurist decides to prefer an alternative ruling over the ruling of the existing law, due to some problems that arise with the strict application of the existing law. And this is when you apply the law does not deliver justice in particular circumstances and cases. Then the question arises, what is the purpose of the law in the final analysis? Is it for the sake of applying the law for its own sake, or to secure the ideas and the ideals of justice and fairness? It is in this regard that istihsan plays an important role. It has been given different definitions according to the various mazahib, and I will be referring to these, but essentially istihsan consists of recourse to ra'ya or a juristic opinion in order to prevent a certain rigidity that arises from a strict application of the existing law. The rigidity may be due to the application of the existing rules or a particular rules of qiyas, that is analogy, and the urge to depart from that to an alternative ruling is motivated by the ideals of fairness and maslaha, that is considerations for public interest. Istihsan is the nearest doctrine in Islamic law to the Western law doctrine of equity and fairness. Although there may be some differences between these two, in the final analysis, the objectives that they both follow are the same: fair solution and justice. In Western law, the doctrine of equity originates in the idea of natural law and natural justice, which stand above positive law. And the courts are authorized to resort to these when the application of existing law runs into difficulties. This idea of natural law and natural justice itself originates in the belief that there are certain principles inherent, the good and bad, and the ideas of fairness are inherent in the nature of things, in the nature of man. But this is not the belief that we subscribe to in resorting to istihsan. Istihsan is within the Sharia itself. It consists of a certain departure from a certain position of Sharia to a certain other position, but it does not claim a rank above the Sharia itself. But these may be some of the approaches. As I said, the ideals of fairness and justice both are in common between istihsan and the Western doctrine of equity. Istihsan is an important manifestation and part of ijtihad, that is trying to find solution to newly arising issues, and it serves the purpose of adjusting the existing law to the realities of changing needs of society and in particular cases, the realities of the law in its application to particular cases. But because of its heavy reliance on personal juristic opinion, istihsan has been criticized by some of the mazahib. Three leading schools, that is the Hanafi, Maliki and Hanbali, accept istihsan as a valid proof and source of judgment, whereas the Shafi'is, the Zawahiri and Shia, they reject it because of that if you give personal opinion such a sovereign play to circumvent the Sharia and depart from one hukum to an alternative, then this is not acceptable to these schools. The jurist may find at times that the existing law causes rigidity, or it is too general, need to be qualified and specified, that maybe it is too specific, it need to be opened up. And the ultimate purpose is the objectives of the lawgiver, that is to secure justice and maslahah for the people generally and also in particular cases. We should not be tied to the rigidities of the literalist application of the law in oblivion to the higher objectives of the Sharia. Imam Malik considers istihsan as a kind of open reasoning, istidlal mursal, whereas the Hanafi jurist Al-Sarakhsi believes that istihsan at the root of it is alleviation of hardship. And he quotes Quranic verses in his support, and that Allah intends to bring ease and alleviate your hardship. Yuridullahu bikumul yusra. In a hadith also quoted, the best of your religion is that which facilitates, which brings ease to the people, enlighten their burden. Imam Malik, who is the principal advocate, so to speak, not of istihsan, but of maslahah. Maslahah is a Maliki doctrine. Istihsan is basically a Hanafi doctrine. But it is Imam Malik who went on record to make this rather surprising statement, that istihsan consists of 9/10 of human knowledge. This is rather a remarkable statement. But Abu Zahra, a prominent 20th century scholar, went on record to say that Imam Malik probably had combined both the idea of istihsan and maslahah when he made such a statement. And in between them, it really encapsulates the idea of this persistent quest for further refinement. This is a perennial engagement, that we try to find better solutions than the one we already have. And this is the essence of excellence in the quest for knowledge. That is the idea that Imam Malik probably visualized for istihsan. Many examples can be given. For example, oral testimony is accepted to be the standard means of proof in Islamic law. Now, this is something that a consensus, a juristic consensus, can be claimed in support of oral testimony. The fact that a witness stands before the judge and testifies in his own word, this is considered to be the most reliable means of proof. Now the times have changed, and realities are such that we have at least equal, if not better, methods of proof in establishing facts. Laboratory analysis, DNA, photography, and sound recording, etc., etc., Are we going to stick to the same position we had in medieval times, or are we going to say that we still accept the realities have changed and we are open to accept this also as a method of proof? This is something that we depart from a certain position to another position. We consider it is preferable, and that is the idea of istihsan. Hanafi jurists, there are some minor distinctions, differences between the mazahib. The Hanafi jurist Al-Karhi characterized istihsan as a departure from an existing precedent to an alternative ruling because of a certain reason and a stronger justification that applies. And from the Hanbali school, Ibn Taymiyyah also characterized istihsan as a departure from an existing hukum to an alternative, a better, a preferable ruling, which is closer to the spirit of the Quran and Sunnah. He ties this istihsan closer to the scripture, so to speak. From the Maliki school, Ibn Arabi gave a very wide characterization to istihsan. He called it the stronger of the two evidences, aqwa al-dalilain. At root of all this is that we depart from an existing precedent or an existing law in favor of an alternative ruling in order to secure the ideals of fairness and justice. Is there any proof, textual proof, in support of istihsan? There is no clear text to quote in support of istihsan, yet the ulama have quoted some verses and some hadiths in support of istihsan. Two verses are quoted, the Hanafi jurists, for example, from Surah 39, verse 18, those who listen to the word and follow the best of it. These are praised in the Quran. Those of my servants who listen to the word and follow the best. يستمعون القول ويتبعون أحسنه. They follow the best of it. أحسنه is a derivative of istihsan. And then again, the same surah, verse 55, وَاتَّبِعُوا أَحْسَنَ مَا أُنزِلَ إِلَيْكُم مِّن رَبِّكُمْ. Follow the best of that which has been revealed by your Lord. In the first verse, some discussion has arisen that the word qawl, those who listen to the word, either can mean the word of God, the Quran, which is most likely, or any speech. And then the question arises, are we within our rights to determine what is best and what is less best in the word, in the speech of God? This has given some rise to some controversy, but the understanding has been conveyed by the jurists that the idea here is referring to certain change in the application of the law. For example, in some cases, when someone commits a crime, the normal course is to apply the existing law and punish. But an alternative course, a better course sometimes can be not to punish, but to pardon. And that may be the essence of the verse, the message of that verse. Sometimes the text also provides a ruling on the maintenance of relatives, for example. There is an obligation, but the text does not specify how much. And here the jurists say that we ascertain what would be best to apply this part of the word of God. And this is the idea of istihsan, according to these observers. Two hadiths is also quoted, and that one is what the Muslims deem to be good is good in the eyes of God. مَا رَآهُ الْمُسْلِمُونَ حَسَنًا فَهُوَ عِنْدَ اللَّهِ حَسَنًا. And then of course the hadith, harm may neither be inflicted nor reciprocated. La dwarara wa la durar fil Islam. Between them, these hadiths encapsulate the idea of what is a truth in istihsan. But then the critics say that these verses, Al-Amidi says that these verses merely praise a certain conduct, those people who listen to advice, to the speech of Allah, and not necessarily to convey the idea of istihsan. Al-Ghazali went on record to say that the message of the hadith, if anything, this hadith could be quoted in support of ijma. What the Muslim consider to be good is good in the sight of Allah, and not necessarily for istihsan. Be that as it may, there are many critics, but as we shall elaborate a little further, there seems to be a certain misunderstanding concerning the basic the substance of istihsan. No one can, in the final analysis, actually refute it. We said that Imam Shafi'i rejected istihsan in theory because of his heavy reliance on personal opinion. Yet a Shafi'i jurist, Al-Amidi, goes on record to say that Imam Shafi'i himself applied it in 3 places at least. He has applied it, and the details are given in the chapter of my book. There is a full chapter on the subject, and other references that are given in the reading list. Brief history of istihsan. We start actually to look for authority in the application of istihsan in the precedent of the companions. And there are occasions when, for example, firstly, one statement that is consistently made concerning the companions, that they were not literalists. Whenever there was a problem, they would look into the Quran and then the Hadith. If they did not find something, they would apply and exercise juristic ijtihad in an unrestricted manner, not be bound by the technicalities of jurisprudence as such. We have in the precedent of Umar ibn al-Khattab, for example, that he made several decisions based essentially on istihsan without actually mentioning the word. At certain places, Umar ibn al-Khattab asked the companions not to marry non-Muslim women, the Kitabiyya, the followers of other scriptures, despite the fact that the Quran permits it. And so one of the prominent companions, a governor, had done that. And he said, if all our prominent leaders do that, what about Muslim women who are also eligible? That was his purpose. There was a case of Muhammad bin Maslama. His neighbor had requested if he could have a right to the water passage running through the neighbor Maslama's land. He needed water for irrigation, but the neighbor did not agree to it. This man can complain to Caliph Omar. He investigated and found that there can be no harm caused by this, but there is a benefit to this neighbor, and he allowed it. There is a departure from an existing rule. The existing rule is that the owner is the master of his property. But here we apply a different ruling. No, the owner has to agree, because there is a benefit, and that is the purpose of good governance. There are other cases and examples I have given, but I cannot engage in detail. As we said, the idea originates in the precedent of the companions, but technically it is attributed to Imam Abu Hanifa, And even earlier, some jurists like Iyas ibn Muawiyah, early 2nd century Hijrah, in Ibn al-Muqaffa, prominent official of the early Abbasids, they have gone on record to apply the text. If it does not work out, apply qiyas, and if it doesn't, change it to a better ruling. Ibn Muqaffa went on record to say that there has to be a certain flexibility in exercise of discretion in the application of the Sharia. The idea, the controversy that arose concerning istihsan and its heavy reliance on ra'ya relates, of course, to this the two currents of the major movements of the Ahl al-Hadith and the Ahl al-Ra'ya. The followers of Hadith, who were basically based in Mecca, in Medina, they would try to find a text for every issue. If they did not find, they would stop and not exercise open judgment and opinion. Imam Abu Hanifa and jurists of Iraq and Kufa, on the other hand, they were considered to be the Ahl al-Ra'ya. If they did not find a text, they would resort to opinion in ijtihad. And there is this connection between istihsan and ra'ya, and Imam Shafi took a very strong stand, considering this as a kind of pleasure seeking in religion, talazzuz wa hawa. What would happen, he says, if a mufti and judge circumvented the rules of Sharia simply because they prefer a certain other ruling or solution or opinion? But this is not actually the position where we stand about istihsan. And so I have quoted many jurists and scholars of the past and contemporary scholars that Imam Shafi actually exaggerated his case. I have some detail about the difference between qiyas and istihsan, analogy and istihsan. Both of these are basically found in the exercise of ra'ya, and they therefore have some connection with one another. Istihsan is also related to qiyas, in the sense that, as I would later discuss, istihsan is considered as a variety of qiyas. I will explain this. Here is a connection between istihsan and qiyas, but the two are different in the sense that analogy or qiyas is a restricted form of ijtihad. It is tied up to the existence of a text, of a hukum in the sources, whereas istihsan is not limited by that factor. Then we have a certain division of istihsan into two basic varieties. One is istihsan qiyasi, analogical istihsan or analogy-based istihsan, and the other istihsan istisna'i or exception-based istihsan. Exception-based istihsan. I will explain this. The first is tied up to qiyas, as I earlier explained. We have, for example, a variety of qiyas which is called qiyas jalli, that is a straightforward analogy. Analogy that is drawn between liquor in a narcotic drug because of intoxication is straightforward. That is qiyas jalli. And it is maintained that a variety of istihsan consists of a departure from a straightforward analogy to a more subtle analogy, from qiyas jalli to qiyas khafi. A more subtle analogy is a second step analogy and a better one. And should there be a conflict between the two, it is this more subtle analogy that is preferred. There is a departure from one ruling of analogy to a preferable ruling of analogy, and that is why it is called istihsan, analogy-based istihsan. Examples are given here. One is about the waqf land, the charitable endowment. There may be the waqf deed. The waqf deed may not have specified the transfer of ancillary rights, the right of passage, the right of water, and this and that with the waqf land. Someone dedicates a certain amount of land in perpetual charity without mentioning that all the ancillary rights are also transferred. Here, one analogy is drawn with the contract of sale, and the answer is unsatisfactory. Whatever is mentioned in the deed of sale is included. If it is not mentioned, it's not included. Then the jurist thinks that this was not the correct analogy. The correct analogy should be drawn with the contract of ijara, lease and hire. And that because taking in the usufruct of the ijara property is the essence of that contract. Whether you mention it or not, it is included. So this time a second analogy is drawn between waqf and ijara, and the answer is that waqf automatically transfers the ancillary rights. This was a rather technical example of istihsan qiyasi that is given. But this is also the kind of analogical istihsan has given rise to more juristic issues. Then the second variety of istihsan I will be discussing is, now the second variety of istihsan known as exception-based istihsan or istihsan istisna'i occurs in 5 or 6 varieties. The basic idea is that this variety of istihsan consists of a departure from an existing text of the Quran or a hadith or a ruling of ijma or a ruling of urf or of because of necessity and maslaha. So you have 6 varieties of exception-based istihsan, and I will be giving some examples. The idea is that this variety of istihsan consists of making an exception to an existing rule, because there is a certain need that we need to do that in order to capture the essence of fairness and good solution. I begin some of the examples that I have given. Also, maybe the jurists are not always in agreement, but we begin to give an example from the text of the Quran, and then to say that this is by way of istihsan. This may sound rather odd, but here is the example. In Surah 2, verse 180, the Quran provides in a text that it has been prescribed upon you when death approaches any of you to make a bequest in fairness to the parents and relative. Now, كتب عليكم إذا حضر أحدكم الموت خيرا الوصية. That is the text that goes that provides authority for making a bequest in favor of parents and relatives. This is a departure from the existing rules of Sharia. The existing rule in principle is that a legal heir is not entitled to a bequest. And if you do entitle parents and relatives to a bequest, then it is by way of an exception. This is an example in a way that we can read a certain genesis of istihsan even in the Quran. And then istihsan, that is exception-based istihsan, in the hadith, in the sunnah of the Prophet, many examples are given. One of these is the contract of ijara, lease in hire. According to the normal rules of Sharia, the object of a contract of sale must be present at the time of contract. In lease in hire, if you rent out a property, the rental, which is the subject matter of this contract, is not present at the time of contract. But Sunnah has validated the contract of ijara despite this abnormality, a departure from a normal rule to something else because the people benefit and the need for it. Istihsan that is based on ijma. An example of this is the validity in Sharia of manufacturing contract or istisna. In a manufacturing contract, someone orders a certain house or an object or furniture to be made for him. Neither the house nor the price are in existence at the time of contract. You may pay a certain deposit or something, but neither are in principle in existence at the time of contract. Yet, istisna has been validated on the basis of general consensus or ijma because of the need of people for such a contract. Here is a departure, in other words, from normal rules in favor of an exceptional ruling, an exception-based istihsan, in other words. We can give examples of istihsan based on general custom or urf. Again, in give and take sale, bay al-ta'atwi. You go to the supermarket or to shops and you place the money and you take the object without pronouncing the offer in acceptance in the formalities of a contract of sale because the general custom has allowed it. Here is a departure from normal rules to something different because the custom has approved of it. The same, we have accepted movable objects to be given in waqf, although waqf can only proceed with immovable property. Yet the customs of people have accepted giving in waqf of books and of tools and so on. Then I give an example of exception-based istihsan or juristic preference that is founded in the idea of necessity or darura. For example, a witness must be an upright person in order to be admissible in the courts of justice. There may be cases, very serious cases, where the witnesses available are not upright, or one of them may not be an upright witness. In the adjudication on the case depends on it. If it plays such a critical role, then the judge may admit a witness of a questionable probity in order to find a solution to the case before him. The same about the normal rule about a judge. A judge, in order to qualify for appointment, must be a mujtahid. Now this is the normal rule, but supposing we do not have sufficient number of mujtahidun to fill up the judicial post, so we depart from that normal rule and accept people of lower caliber, a muqallid or an imitator who is not a mujtahid for appointment to judicial post because of necessity. And there are other examples that I have given. Similarly, an exception-based istihsan may proceed on the idea of maslaha or considerations of public interest. An example of this is the responsibility of a trustee. The trustee in principle is not responsible for the loss or damage to goods that are placed in his or her custody. Like a tailor or an artisan, you place a certain property in their custody, then a fire or damage causes damage to that property. Is he responsible? Normally not, but the ruling has originating in a ruling of Caliph, fourth Caliph Ali, that unless you do hold the trustee responsible, then the safety of the marketplace, in the transactions of the marketplace, will be harmed. It's in the best interest of maslaha of smooth flow of transaction that we hold the trustee responsible. Here again, we depart from a certain ruling to an alternative, a preferable ruling based on the idea of maslaha. There is a certain controversy over the principle of istihsan. I mentioned earlier that Imam Shafi speaks of istihsan as pleasure seeking in Sharia, and on the other end of the spectrum, I quoted also Imam Malik, who speaks of istihsan so highly as to characterize it as 9/10 of human knowledge. There is obviously the truth is somewhere in between, and Imam Shafi, in taking that position, he quotes certain Quranic verses to support his argument that istihsan is just indulgence in arbitrariness. In Surah 75, verse 36, يَحْسَبُ الْإِنسَانُ أَنْ يَتْرُكَ سُدًى. Does man think that he has been left without guidance? And then in the well-known verse in Surah Al-Nisa, if you dispute over a matter, then refer it to the Quran and to the Sunnah. And Imam Shafi says that that is the way to go. And to refer to those sources is by way of qiyas, analogy, and not by way of istihsan. Having said that, I also quoted a Shafi jurist, Al-Amidi, saying that Imam Shafi himself has actually acted on the idea of istihsan in the case of mut'a, for example. In the case of mut'a, in the case of shufa, shufa, for example, is the right to preemption of the sale of a neighboring property. And the neighbor has the right of priority right to buy, but how long should the seller wait for that? Imam Shafi says, I consider this preferable that the shufa is limited to 3 days. This is a istihsan. There are some other examples. Imam Al-Ghazali is critical of istihsan in a different way, especially that the second in the larger variety of istihsan, exception-based istihsan. He says, why call it istihsan if it is validated in the Quran or Sunnah or Ijma? These are the rulings of Quran, Sunnah and Ijma as such, and not rulings of istihsan. Al-Shatibi, the well-known jurist and advocate of the idea of the maqasid al-sharia, he says, unlike the view that is advanced by Imam Shafi and some Shafi jurists, istihsan is not indulgence in arbitrariness. A jurist who resorts to istihsan actually engages in higher caliber of juristic thinking, finding a better solution to one that already exists, but there is some difficulty. This is the essence of the pursuit of excellence in human knowledge and experience. Among modern scholars, Abu Zahra, Ahmad Hassan, and also Nicholas Aghnidis. They have all gone on record to say that the substance of istihsan cannot be denied, and that the idea of istihsan to be criticized in the way that we have had it from Imam al-Shafi is actually exaggerated. Maybe there is some dispute over certain varieties of istihsan, but the substance of istihsan is beyond actually dispute. To conclude my discussion on the subject, istihsan is not really a principle that validates legislation in enactment of normal original rules of Sharia. In other words, it is not a principle of legislation as such, but a principle that seeks to purify, seeks to find the better ways for the application of the existing law. In other words, facilitate best solutions that reconcile with existing realities, especially before the courts of justice. And it would suggest that istihsan is really more useful for the judge in the mufti than it is for the lawmaker in parliamentarian. It is in the case of the jurist in judge in mufti that istihsan can find its best application. Yet the realities of our time and the history of jurisprudence that we have known, judges and jurists are rather reluctant actually to resort to istihsan and to apply it. Maybe because of the controversy that has arisen over it, or that we lack a certain sense of initiative. I personally have not seen many rulings of the muftis and judges based on istihsan, and there is no reason why we cannot actually apply istihsan in the sense that we find credibly applicable. It should be applied, and judges should take the initiative that it takes to give istihsan its proper place in adjudication in fatwa as we have today. Thank you.